Baker, and this is The Secret, How to Fight Child Protective Services and Win. I'm with attorney Vince Davis and with Dean Tong. We're going to take another call, and it's Allie from California. Hey, Allie, are you there?
Yes, I'm here.
Thank you for joining us tonight.
Thank you. I had a question, probably any of you can answer. I'm waiting for my TPR in June, and I've recently finally been granted a Marsden hearing. It was my second appeal for a Marsden, and I was granted one. But unfortunately, it was right before the 18-month review hearing, so a lot of what I was trying to bring up the whole time at court, the judge wouldn't listen to. But I've recently found out that in California, at least, I was told, I should say, that a parental plan that you can make with the other parent will stand in CPS, or stand against CPS, I guess, is what I'm trying to say. Because myself and the father had a custody arrangement that we amended outside of court that it says that we could do. And we put it in just plain English, we split custody equally. And CPS would not look at that. I tried to present that at my first detention hearing. I did not live with the father. I lived separately. We had custody where we split a week on, week off with our son. And when he was detained, he was in the father's custody. I immediately asked to have my son, and the social worker put him into a foster home. They said they would not look at my custody arrangement because it was not signed by a judge. And I'm confused. I read somewhere that parental plans are accepted and then other places that they aren't. Do you know which is which?
Sure. Well, first of all, it doesn't matter. They filed a petition apparently against both of you alleging some type of abuse by the father and or by you. Now, at the time, in the very first part of the case, which I call Module 1, you had the opportunity to prove those allegations false, and even if they were proven to be true, they still had to prove by clear and convincing evidence that you were a substantial danger to the child, and there were no less restrictive alternatives. Now, do you remember having a trial at the very beginning of the case? Like within the first couple months?
Like an evidentiary hearing type thing? Or?
Yeah, exactly.
No, I was never granted an evidentiary hearing, which was part of my first Marsden with my first lawyer. I've also never even been granted a CFT. I've never had a bonding study. I have my 6-year-old daughter at home still, sole custody, and they've never been awarded a sibling study.
Well, wait a minute.
Uh-huh.
You have a child at home and they took another child from you?
Correct.
Okay, so that right there raises red flags.
Yeah.
Do you have, when you asked for a Marsden hearing, so I assume that you have a court-appointed attorney?
Yes. I asked for a Marsden hearing at the second court date for my first lawyer. This was back in September of 2019. I was finally granted one in December of 2020.
Okay, so this is what I need to know. Did you appeal any parts of these hearings? Take it to the Court of Appeal?
Yes, I did.
And did you lose?
Yes. I did, and at the first paragraph on the appeal, where they made their final decision, it said that the appellate court affirmed, which I was confused about. But I have appealed the detention and jurisdiction hearing and their findings because they only had placed 300B and G on me, and then they eventually, I believe, dropped the 300G.
Okay, but what was the B about? What did they say you did wrong or were at risk of doing wrong?
They said that I was not available at the time my son was detained, which was a lie, and that I couldn't care for him or something like that, and that I guess I didn't know that the father was going to commit a crime, and I should have. And so they said I had put my son in danger by letting him see him with his. It was a custody order. I had to.
Yeah, there's a family law or an agreement that
Yeah.
you. It sounds very interesting. Is there a way that you and I, this is a radio show, everybody has a very short period of time. We got commercials, we got news, all that stuff. If I give you my telephone number, would you give me a call tomorrow so I could talk more in detail with you about it?
I already have your number, Mr. Davis. Yes, I would.
Okay. Call tomorrow. I may not be in the office, but you can leave a message or you can make an appointment to talk to me.
Okay, I would love to do that.
All right. And also, have you been interviewed by Cynthia Becker on the what's the name of your show, Cynthia? I forgot. The reality series CPS The Horror Stories?
Yes, that's
no,
it.
I haven't. But I would love to if she would want to.
Cynthia, how can she get in touch with you?
Sure, you can message the Facebook page, the reality series, CPS The Horror Stories, or you can message me or call me at my direct number, which is 626-594-5526.
Okay. Yes, and I've messaged you too before, Cynthia, as well. So.
Go ahead and message me again and remind me that we talked on the show today, and I'll schedule you for an interview.
That would be great.
I want to thank you for calling in and thank you for listening. Call in about a month and tell us an update on your case.
Okay, I will do.
All right.
Hey, Vince.
Yes.
I was going to ask Dean, because when he was on the show and we did an interview, we talked about how CPS will take one child or more and still leave you with a child or children in your home.
Well,
this does not make sense to me.
Doesn't make sense to me either. Dean, what do you think?
Well, they're cherry picking the data council, in my opinion. And they're concerned only about the child at bar, if you will, which is the child coming under allegations, whether it's a hearsay allegation or whether it's physical abuse or whatever the case may be. The other kids at home, obviously not part of the allegations. You would think that would be a risk failure to protect issue, but it's not in many cases. So I've seen it, and of course in my state of Florida, we have a statute where if they take your kids and you have a past history, with the system, with the government, with CPS, you have a baby on the way, they can actually be there in the delivery room and take that baby upon birth. It's called prospective abuse. It's called prospective abuse based on your past.
Right. But they still have to prove a case. And I was, I will say, trained by an old juvenile court commissioner who's retired now, but he used to say, if you're a danger to one kid, you're a danger to all kids, right? It's almost impossible to understand that you can lose a kid and still have a child in your custody.
Well, and I've been brought in by lawyers in cases where
2 minutes
testify against violations of the policy and procedure manual published by DCFS that they're supposed to adhere to. I was brought in a case in Rhode Island almost 10 years ago where I think I cited 25 breaches of policy, and when I got to number 25, the judge was shaking her head and said, "Thank you, Mr. Tong, I've heard enough."
Very good. Hey, we're about to take another commercial, but Dean, I have a question for you. It just struck me.
Yep.
Do you act as an expert witness in civil rights cases against CPS social workers?
I have consulted in probably half a dozen 1983 cases, and I have participated in depositions of CPS child protective investigators and forensic interviewers and therapists and the like. Once the court denies motions to dismiss, yes, when it gets into discovery. But the case has never progressed far enough for me to testify in a state or federal court on a lawsuit case. But I am queried by attorneys to consult and certainly have handled probably half a dozen of those 42 U.S.C. 1983 cases.
Very good, very good. Okay, folks, we're going to take another break right now. We'll be back. This is The Secret, How to Fight Child Protective Services and Win. Stay tuned.